this opportunity at your death to take your $2 million lifetime exemption. Rather than wasting that and instead transferring all of that to the marital deduction trust, why not go ahead and peel away in that $4 million example? Why not peel away $2 million, put it in this bypass trust, which would be subject to taxes. It would be counted as being in your gross estate. So except for this lifetime exemption, this would be taxable, a taxable estate at your death. Why not take advantage of that and use your $2 million exemption? There you've pulled out $2 million, you've put it in this bypass trust, which I'll talk more about in a minute, this separate trust that allows you to keep it from being taxed at the death of your spouse. So you have a situation where your $2 million would otherwise be taxed except for your exemption. You fully take advantage of that exemption. As a result, it's not subject to any tax later on because it's not a piece of the marital deduction trust. And then you have left the $2 million in our example, which would flow out to the estate at your wife's death. That would flow out, and then that would be taxed normally except for the exemption, which would be available, and as a result, that itself would not be taxed. So you've essentially avoided any taxation on that $4 million. So you can see that these numbers would apply to any number above these exemptions. So anytime you get above $4 million, I know some of you, when you hear that number, you're thinking, wow, $4 million is a big number. And then others of you are thinking, that's where I am, or that's where I'm sure I'm going to be in 10 years. $4 million is not an unusual estate, given values of real estate and other assets that people often have included in their estates. So for many people watching this show who in fact will die beyond 10 years from now, you're going to be, assuming the tax laws continue as they are today, you're going to be in a position where you will need to take advantage of this, or at least if you want to minimize your taxable estate. So now remember what we're talking about here, 45%. So taking advantage of this opportunity of utilizing your exemption is something that is just wasteful to ignore. And I can tell you a lot of people don't do it and they blow it off. But you can do the math very quickly and compare that to the transaction cost of a lawyer helping you prepare this AB trust, and the savings are huge. So that's one reason that people often talk about marital deduction planning. Now, if you think about it, though, you can end up with a disproportionate allocation of assets, and sometimes you can have a poor spouse, a spouse in whose name there are very few assets, and they don't simply have enough to take advantage of their lifetime $2 million exemption. So you want to avoid that, and that's one reason that when you sit down with an estate planning lawyer, they'll often begin talking to you quickly about equalizing the marital estate, meaning making transfers. There are a variety of ways to do this, whether it's direct transfers, whether you use a trust, but there are ways to equalize that estate to assure that the first spouse that dies is not so poor in terms of having assets in their name that they're unable to take advantage of the $2 million lifetime exemption. So you want to put them in the position where they would otherwise be taxed for that, but for their exemption, and then you can often put that in a bypass trust. Let me talk about this issue of a bypass trust. This trust serves a lot of purposes. It's not simply about saving money on taxes, and certainly it does that, as I just demonstrated, but it also plays some other important roles. One concern that we find a lot of our clients have, a lot of guys have, is that they're afraid that maybe their wife will marry someone after their death who will take advantage of them or may not manage the assets as they would like. I know that some of you are very proprietary about the fact that you've worked hard over the years and maybe you've accumulated a business or substantial assets, but you've done it perhaps more by your labor than your wife's, and as a result, you are concerned about how this money is used at your death. So that's one of the issues that underlies the concern about creating a bypass trust. Another is those of you who have second families, and many of you who are going through a divorce now, or you've recently been through a divorce. You probably have children. I'll bet statistically that you'll remarry, and when you do, there will be concerns about what priority will these children have vis-a-vis children that exist from the new marriage versus those from your wife's prior marriage. And that complicates estate planning, and it makes more critical the role of trusts and other devices whereby you can extend what's called in estate planning the dead hand. You can extend your hand from the grave, so to speak, and exercise certain controls. And it's very reasonable to want to do this, and in fact it's the only way that you can have some level of confidence in your last years that your estate will go toward the purposes that you want it to go toward. Now, you can actually do this with a marital deduction trust too, and I'll get to that in a few moments because that's a little more complicated. But let me just introduce you to these ideas on the bypass trust. So what typically will happen is some amount of the money will go on the bypass trust. Now, generally you want it to fully take advantage of this exemption. Now, sometimes people will put more in there. I mean, they recognize that there are some tax implications if they don't take advantage of the marital deduction trust, but for various reasons they want a central place to plan their distributions, and they'll sometimes put money beyond the $2 million exemption in this bypass trust or this credit shelter trust, and they'll pay the taxes in order to have this organized distribution plan. Now, there are other ways we can deal with that, and again, we'll come to that in a few moments. So how does this bypass trust work? Well, it's an irrevocable trust. We've talked before about the fact that a trust has a trustee whose job it is to run it, meaning they run this arrangement for the benefit of the beneficiaries, and the instructions as to how they run it for the beneficiaries are in the trust documents, which you create as a piece of your estate planning. It can either be in your will, it can be what's called a testamentary trust, or it can be a trust that you create during your lifetime called an inter vivos trust. But whether the trust pre-exists or it comes into existence at your death, still, what it will do is it will assure that the assets that are placed in that trust are used in the way that you prescribe. But you have to be careful here because you want to leave some flexibility on the part of the trustee to deal with emergencies and contingencies. So often clients are reluctant to simply have income paid out because they want to allow for certain emergencies and other needs. So you can see that the judgment or the discretion of your trustee can play a critical role. So you want to think about who that trustee will be. Well, where you end up with a bypass trust that involves substantially in excess of a couple $1 million, then an institutional trustee can be really critical. And it's not even unusual to have an institutional trustee in conjunction with maybe a family member or a friend that you trust. And that sort of co-trustee arrangement often works, but you've got to empower one with sort of tie-breaking authority. But however you do it, you've got to have some flexibility built in, and you've got to identify successor trustees, particularly where you're talking about a living human being as the trustee versus an institution. You certainly have to have successor trustees. Now, I'll tell you that the way these are often set up, they're often set up to allow you to distribute income and to allow your surviving spouse to have access to monies, but yet to place limits on it. And what you want is to walk a line between allowing your surviving spouse too much access. Too much access has two problems. One is what we've already talked about. You created this because you want some limitations on the potential for abuse, not so much directly by your surviving spouse, but by those around her. So you want to have limitations for that purpose, but there's an even more critical purpose for some of you, and that's the tax implications. If you give your surviving spouse too much authority over the money that you put in the bypass trust, remember there are two trusts here. There's the marital deduction trust, there's the bypass trust. This is often called an A-B plan. Talking about the B trust. If you give the surviving spouse too much authority over the content of that, then she can effectively be deemed to have control or ownership of that trust. The effect of that is that it's in her estate. So you end up failing to take advantage of your $2 million exemption because it essentially went into the marital deduction trust because she has complete control of it, and as a result it'll be taxed at her death. You don't want that to happen. And you can see the logic. The IRS is saying, look, if in fact what we have here is a thinly veiled extension of funds to the surviving spouse, which is masquerading as a bypass trust, we're not going to honor it. We're going to go to the heart of this transaction, and we're going to say that essentially all the money is to be treated as a marital deduction trust, or marital deduction funds rather, and we'll tax it all at her death. So you got to have parameters, and a common parameter that's used, and this is a phrase that's used throughout the industry when you go see your estate planning lawyer, I'd be surprised if this doesn't come up, ascertainable standards. Another way to put that is there's an acronym, HEMS. Health, Education, Maintenance, and Support. It's called HEMS standard. What this is, it represents, is something that's tried and true in the courts. The courts have placed their blessing, and even the IRS has reluctantly conceded that this is a standard that's enforceable, and we'll regard it as a meaningful standard. And we won't say that someone who's the beneficiary of a trust where there's a health, education, maintenance, and support standard permitting the funds to be used for those things, we won't deem that